So the DOJ through AG Bondi, 25 states, and now multiple 2A organizations have joined the fight against statewide concealed carry bans, and these type of laws are currently in front of the Supreme Court. So let's break down what is happening. Now, really quick before we jump into this video, if you want to support the channel for free, please consider subscribing to the channel. That helps the channel to grow. Just also double check to make sure YouTube is not unsubscribed to you, because they love to do that. And then just drop a positive comment down below, because that helps to tell the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, I have an update for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within those states. You may recall that recently the Ninth Circuit issued a decision on multiple concealed carry laws, which were passed in direct response to what the Supreme Court said in their Bruin decision. One of those was the California SB2 case, and then the other one was Hawaii's concealed carry ban laws that they passed in direct response to Bruin. The case that's currently seeking Supreme Court intervention is the Hawaii Wolford versus Lopez case, and this challenge revolves around a preliminary injunction and the Ninth Circuit finding that states and their catch-all public property carry bans are in fact permissible under the Second Amendment, and that Bruin does not change that outcome. Recently, to the surprise of many, the DOJ and AG Bondi have stepped up in support of this challenge against Hawaii's carry ban. They recently filed an amicus brief to the Supreme Court arguing that it is finally time for the Supreme Court to review these carry bans that were passed after Bruin and to stop this lower court defiance. There was also a mention in that brief that they believe it's time for the Supreme Court to address other issues like rifle bans and magazine bans that have been passed in various states. This effort has now been joined by 25 states and multiple Second Amendment organizations who are also calling for the Supreme Court to stop the active defiance that is happening currently at multiple levels. This law, like others, tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property only if the owner of that property provides express permission to those individuals to do so. In Hawaii, that permission could come from posting signs or from the property owner telling you verbally that you can conceal carry at that location. However, that doesn't really operate like that, because when is a property owner going to tell every single person that comes into their location that they can conceal carry? Prior to Bruin, Hawaii's laws operated as may issue, but essentially still no one even in the state of Hawaii could actually carry under the may issue system. In 2018, in fact, the Ninth Circuit noted that Hawaii had issued only 4 concealed carry licenses to private citizens in the past 18 years, and that one county had not issued a single carry license ever. However, in Bruin, the Supreme Court held that the Second Amendment guarantees a general right to public carry arms for self-defense, and that may issue licensing regimes for carrying handguns, like Hawaii's pre-Bruin regime, violated that right. Hawaii, in response, passed Act 52, a statute that overhauled the state's concealed carry laws. But through that new law, they created a hyper-restrictive system that was just as bad, if maybe even worse, than the one that existed prior to Bruin. Because of this, plaintiffs along with 2A orgs sued the state to strike down that new law. Now, on review, a district court issued a temporary restraining order, also known as a TRO, which was later then converted to a preliminary injunction. In that decision, the district court blocked the private property rule as likely a violation of the Second Amendment and inconsistent with what the Supreme Court said in Bruin. This case then made its way to the Ninth Circuit along with the California carry ban case, which was a challenge to SB2. And on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction issued by the district court in Hawaii. The Ninth Circuit relied on older restrictions on hunting on private property to support this statewide carry ban that was in place in Hawaii. After that, the plaintiffs asked for the Ninth Circuit en banc panel to review this case, but that was denied. Now, in that denial, there were dissents from multiple judges. In that dissent, he argued that the private property default rule effectively nullifies the Second Amendment rights of Hawaiians and has no grounding in the historical record. Now, this horrible law and the horrible Ninth Circuit ruling has made its way to the Supreme Court on an emergency basis, and the plaintiffs are asking for the Supreme Court to step in on an interlocutory emergency basis and strike down what the Ninth Circuit said. Now, this case theoretically had a long shot of getting Supreme Court review since it was still in an interlocutory preliminary injunction stage, and the Supreme Court categorically has denied a lot of those types of 2A cases. Typically, the Supreme Court wants final merits cases when it comes to the 2A legal issues. When it comes to other legal issues, they've taken other legal cases at the interlocutory posture, but they've avoided all the 2A cases at that stage of litigation. However, now things may change in the United States through the AG Bondi and the DOJ have stepped up in support of the plaintiffs in this lawsuit against the state of Hawaii and that concealed carry ban. Now, even better, you have the Trump administration that was joined by 25 states and now also multiple two-way organizations who are calling for the Supreme Court to finally take up this type of case, take action, and essentially correct what is happening at the lower court levels and what's happening with some of these states directly defying Bruin. Now, in the recent amicus brief filed by the federal government, they stated that the near-complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense, just as states may not limit that right to those who show a special need for self-defense. States may not limit that right to those who aimlessly wander the streets. Now, again, one of the interesting things with that brief filed by the federal government and the Trump administration is they're saying it's time for the Supreme Court to step in on this issue, even at the preliminary injunction stage. Now, these arguments are echoed in briefs also filed by 25 states and then also Second Amendment organizations who have jumped in to file amicus briefs in support of striking down this Hawaii carry ban. In the brief of the 25 states, they argued that Bruin reassured law-abiding gun owners that the Second Amendment was no longer a second-class right, but lower courts have largely failed to follow through on that promise, resorting to manipulative en banc practices, ahistorical interpretations of covered arms, and improperly calibrating the level of generality for Bruin's inquiry. These incursions on citizens' public carry rights will continue to grow unless the court intervenes. They went on to state that each of these ploys chips away at the scope of citizens' Second Amendment rights, and if unchecked by this court, Bruin's reassurance will be little more than an empty promise. Now, like I mentioned, multiple two-way organizations have also jumped in and they're echoing the same type of issues, saying that the Supreme Court, if they don't get involved, essentially the Bruin analysis means next to nothing. They state that if this court denies certiorari, there will be no meaningful right to carry in Hawaii for at least 7 years while the litigation proceeds. They go on to state that the Ninth Circuit's hostility towards the Second Amendment is well documented, having recorded an undefeated 50-and-old record of upholding gun laws before Bruin. Bruin changed nothing for the Ninth Circuit, and the Wolford ruling is not even the most recent example of the court giving a judicial middle finger to this court. So brazen has the Ninth Circuit's defiance become that even when the Wolford panel disgracefully relied on a racist law to justify Hawaii's law, the Ninth Circuit refused to correct it, denying en banc review over the dissents of 8 judges. Unfortunately, the Ninth Circuit has been encouraged by this court's reluctance to take Second Amendment cases in an interlocutory posture. But if there was ever a perfect case in which to make an exception to this court's preference of not deciding interlocutory matters, it would be this one. So here you have the federal government, the Trump administration, 25 states, and multiple two organizations saying that this is the case that the Supreme Court needs to step in on an interlocutory posture because all the lower courts and all these states know that there has been inactivity by the Supreme Court after Bruin, and if they go unchecked, nothing will really change, and essentially Bruin becomes an empty promise and really has no teeth. Currently, Hawaii's response brief is due on June 4th, and then there will be some final reply briefs from the petitioners. But with the DOJ's brief, the 25 states brief, and now all these multiple two-way organizations, there's potentially a strong chance the Supreme Court would grant review to this case, even though it's in an interlocutory posture, because Bruin was very clear that May issue regimes were impermissible and that states needed to start actually issuing permits, and they needed to do it in a way that, aligned with the Second Amendment. But you have a lot of these states that said, no, we're not going to do that. We're going to pass even more hyper restrictive laws. We're going to essentially maybe issue permits, but even if we do issue permits, which a lot of states aren't doing that, but even if they do issue permits, we're going to make the permit essentially useless because you can't carry anywhere lawfully. So the hope is that the conservatives on the Supreme Court now have a strong signal that from the administration, from majority of the states, and from the two-way advocates at large, that it is time to support striking down these concealed carry bans and upholding Bruin and giving Bruin more teeth by striking down these types of laws and lower court defiance. So again, a lot is developing in this case, and it seems like there are some good signals coming out to push the Supreme Court to step in on an emergency basis, and we'll see how the state of Hawaii responds to all of this in the response brief. So as we get more information, as it develops, I'll let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.